any interest in or standing to really argue or state a position about. Do you agree, Mr. Williams?
I agree.
Okay, so really what we need to do is consider the order to show cause, the issues that I've raised in that. I'll go ahead and rule on that. Then we're going to move to the motion that was filed by the state to revoke bond. All right, so Mr. Claypool, what I want to do is I want to deal with the order to show cause. I do realize I asked other local counsel to be here. I did that because as Florida lawyers, they're obviously also charged with the duty and responsibility to make sure that the rules of professional conduct are followed. I know you've read my order. It's fairly straightforward. I have read your response. I'm just going to set on the record the basis for us being here. I do want to ask this question, though. I saw a response filed to the order to show cause. Was there any written response filed to the state's motion to revoke bond? Did I miss anything?
The only thing that was filed intentionally was a affidavit by Ms. Dippolito.
Okay, yeah, an affidavit, but not a any type of formal response. So it was just an affidavit filed, no formal response.
That's correct. I'm going to argue.
Okay, that's fine. All right. I think what we need to do first, I think it makes sense to handle the order to show cause first, and then we'll move from there to the state's motion. Just to state those matters which were set forth in the order to show cause, and why we're here on that, Mr. Claypool, why I directed you be here. As you know, you're appearing pro hoc vice. You are not a Florida lawyer, which means you appear by grace of the court. A Florida lawyer obviously has the right, the absolute right to appear in court. As an out-of-state lawyer, you don't have that right. You serve at the grace of the court. One of the things that you're required to do, obviously, is to comply with the rules of professional conduct, and in particular the Florida rules of professional conduct. I entered this order to show cause based on a news conference that you conducted immediately following the conclusion of the second day, I believe, of the testimony on the motion to dismiss based on outrageous government conduct, objective entrapment. So immediately following that, it was brought to my attention that the following statements were made at a called news conference. And I'm paraphrasing somewhat, but I'm pretty close to the exact verbiage. The statement made was that if the judge follows the law, the motion must be granted. If the judge follows the sensational nature of the videos or the drama in the videos or bows to public pressure, the judge is likely to deny the motion. I consider that to be a violation of the rules of professional conduct. I think it commented directly on the integrity of the court. And my major concern, to be honest with you, Mr. Claypool, is that at the conclusion of the evidentiary hearing, second day, when you're making your closing arguments to me, you're beginning to make your closing statements to me, you began with a statement that was very similar to that. You said to me, if I follow the law, this motion must be granted. At that time, I cautioned you that that was not correct, that determination of this motion would be based on the law, but would also be based on my determination of the facts as I decided from the evidence. And so to go out and repeat that comment to the press in an open forum, I felt violated the rules of professional conduct. So what I'd like you to do, I've read your motion, your response, so I do understand your position. I'd like you to respond to that, and then we can discuss that further, Mr. Claypool.
Yeah, thank you, Your Honor. Would you like to approach your...
I think for recording purposes, you're going to be better off speaking into those microphones.
Sure. First of all, Your Honor, I'd like to apologize to the court. I never, ever intended on trying to undermine the judicial process, and I mean that from my heart. I think if the court looks back at how I've handled myself in the courtroom up until the comment was made, I've been very respectful and dignified, not only to Your Honor, but to the witnesses, to Mr. Williams. And when I made the comment, first of all, I'd like to back up and respond to one remark you made. I absolutely never said in a press conference, you cowering to public pressure. Never said those words, and if we've got to get the entire press...
I don't think you said cowering to public pressure. I think you said if I'm affected by public pressure or something to that effect.
Respectfully, I mean, if the court...
Go ahead and tell me, Mr. Claypool, what you believe you said.
Sure. What I was saying, Your Honor, and we sat through that whole afternoon. It was an emotional afternoon. This is the first time I'm hearing my client talk about this case under oath. I heard the tapes, and what I meant when I was commenting on the tapes, Your Honor, in a heartfelt manner, I will share this with you. It's embarrassing to say it in a public forum, I will tell you that. I felt like the tapes were compelling. It was painful for me to sit in that chair and hear those tapes, Your Honor. I can't. That's what I meant when I said them. Like, what I was trying to say was, how can you ignore the tapes in making the determination? So that's what the intent was. In retrospect, if I could go back, Your Honor, I would have said it a different way. Okay, and I apologize to you profusely for that. That's the first thing. The second thing is I brought a tape with me, and counsel forgot to bring his laptop, but I would ask the court to consider, this is a very short excerpt right before I made the comment that's at the core of your Honor's.
I'll accept your proffer.
Yeah, I would like to proffer this as evidence. And I said clearly, Your Honor, I wasn't just, I want you to hear this. I said shortly before that, we have a very fair judge on the case, and I even said that the judge is doing his best to allow evidence in from both sides to make, quote, an informed decision. So I think if you consider the comment that you're concerned with, and by the way, I don't blame you for being concerned about that comment, but my intent was never willful to undermine the judicial process. And I think this helps you with kind of a guideline to show you that I never intended to undermine the process or disparage it. It was an emotional moment. It was a charged hearing. I was asked a pointed question. By the way, the question was, what do you think your chances are? It wasn't, what do you think of the judge? I've never said anything bad about it, Your Honor. I highly respect you. I think you've been very fair, and I have it on tape for you. So I would like you to at least consider my proffer to hear that I was saying.
Well, what I'm saying is, Mr. Claypool, I will accept your representation that that's what's on there. If you want me to listen to it, I will, but there's no reason why you would get up and tell me something's on a tape that's not. So I'm going to accept your proffer of that
Right.
in connection with this hearing.
So I just want you to know, in closing, I'm not going to repeat, unless the court wants me to, I made some other arguments in the brief that I think if the court's...
So I've read and considered...
Yeah, if the court's inclined to revoke my status on the case for Ms. Dippolito, I'll go into further discussion about the Sixth Amendment and what have you. But at the end of the day, Your Honor, I mean, I'm very passionate about what I do. I have spent hundreds and hundreds of hours on this case, between myself and my staff, close to 1,000 hours, having to start from scratch on this case to understand it so that I could do an effective job. I take my job very seriously in representing Ms. Dippolito. So I've got a lot vested in the case. We're close to trial. I don't want to lose that opportunity to be able to advocate on behalf of Ms. Dippolito. And again, I mean it. And by the way, that's why I decided to come here alone too. You know, I could have brought somebody else in here. I wanted you to look me in the face and hear from me that I am very, very sorry for the comment. I didn't mean it in the manner that you have interpreted. I respect that you interpreted it that way. But that hearing this afternoon was painful for me, and that's why I mentioned the videos. It was excruciating. And the comment about the law was that I felt it was nothing more than a feeling passionately that I thought we had found some cases that I thought were helpful to us. And my mind as a trial lawyer was man, these cases are, these cases really are helpful. Maybe we have a shot.
I understand.
So,
There is no problem with the lawyer saying and advocating for their client and saying, I really think the law supports us on this. There's never a problem with that. We think we have an excellent motion. We think we have an excellent presentation.
Right.
There's nothing wrong with stating that we believe the law supports us. What concerned me was that the comment appeared to set up this dichotomy where if I follow the law, I must grant your motion, but if I'm influenced by things other than the law, public pressure, and we need to get into what was said there, or into sensationalism, that would guide and lead my decision, and to set those two things up in that manner is what caused me
Right.
concern. Because you're permitted as an attorney to stand up and say, I think the law supports my case. I mean, attorneys do it all the time. I think we have a good legal argument. I think we have good facts to apply to the law. So that is not what concerned me. I want to be clear. It's setting up this commentary where it would appear, particularly when the motion has been heard and is under advisement and I have to make a ruling, that candidly my integrity is going to be decided by the method or by the resolution of the motion. And that's what concerned me, Mr. Claypool.
Okay.
Let me say this. I accept your statements to me. I accept what you've told me. I accept that you did not intend any disrespect by that. I will tell you why you did not argue it. Also, it's extremely important to recognize there are a lot of things that are remedies of last resort. Striking pleadings, striking witnesses. A remedy of last resort is denying a client of their chosen counsel. So that's a remedy of last resort. I find no reason to exercise that remedy in this case. I accept what you've told me. I accept that you did not mean it in the manner in which I apparently took it. I do accept also that it was an emotionally charged hearing. I'm certain that it was for everyone involved. And so I accept your explanation, Mr. Claypool, and I am not going to revoke your status to appear here pro hoc vice. I accept what you said. I assume moving forward we won't have any instance where I have any concern about whether or not you're following the rules of professional conduct. And again, just for local counsel that was here, I mean, the reason I wanted everyone here is because obviously when you have someone appear pro hoc vice, someone's standing up as a floor lawyer and saying, this person is worthy of appearing in court. And that's why I asked you to be here. I don't need anything further from you. These statements were made by Mr. Claypool. He's responded to those. So I do appreciate the fact that you're kind of lawyered up here, but it's really not going to be necessary at this point. I think the more significant thing now is to turn to the defense's motion. So, Mr. Claypool, I appreciate your candor. I appreciate the fact that you've offered and extended an apology to the court as to how that may have been interpreted, and I accept that. Okay.
I appreciate your time this afternoon.
Okay, so let's, that's the order of the show. If you want it filed, you can. I'm accepting what you represent to me has been said on that tape. I could always go back and look at it, but I see no reason why you misrepresent that to me. Okay, perhaps from your perspective, more or less significant, I'm not sure. We've got a motion by the state. Mr. Williams, you have moved to revoke, I guess really in-house arrest is what you're moving to revoke, bond based on a violation of the court's order and rules with respect to in-house arrest. So you go ahead and address that, and I'll hear from the defense.
Because it came to light, I guess you're the one that brought it to light.
Well, let me start with a question, Mr. Williams. This occurred like in December. I mean, it's. I know I put it in the footnote, and perhaps that's what brought it to your attention. But
I didn't watch it. No one ever alerted me from house arrest that there was any.
I mean, you just discovered it 3 months later. I mean, I think it aired in December.
I haven't seen it, Judge. I didn't watch it.
Okay, so your explanation for not filing this sooner is you just didn't see it,
I did not see it.
and you were not aware of it until I basically parenthetically said something in the footnote.
So you brought it up. I then contacted in-house arrest to ask if they had received any requests to meet with 2020 down in
All right.
another location. They told me they had not. They told me they actually went a step further. They had watched portions of the video. They then Google mapped Mr. Aguilar's office, and they could tell that the video images that they saw from the television program actually took place down there. Mr. Aguilar confirmed that with me, so there wasn't an issue.
I didn't think that was going to be the issue. I thought there would probably be other issues to be raised, but yeah, I didn't think anyone was going to say the interview didn't occur in Miami.
I didn't know. I've never been to his office. I have no clue. I didn't see the episode, so I was just trying to piece together from witnesses without, and I still have today not seen the episode. I'm not interested. Maybe somebody else will look at it for me. And then...
All right, well, go ahead and just for the record, I mean, I've read your motion. I know what the basis of it is. Your motion is that the order that I entered allowing travel down to Miami-Dade was for purposes specifically of meeting with counsel for preparation of trial. That's what my order says, verbatim. And your position is that this was not for purposes of trial and therefore is a violation of my order with respect to in-house arrest. Is that pretty much so?
Absolutely. She sits in a position that she was convicted of this crime once. Other than an issue that occurred during jury selection, she was sentenced to 20 years in the Department of Corrections. She has been on house arrest. She knows that it's house arrest. She's in jail in her house. This isn't a vacation. This isn't she gets to do whatever she wants and choose what she pleases and can come to the court for things that she thinks are appropriate and what are not. She's in jail in her house. And for good reason, she's in jail in her house. And this was a non-issue to bring before the court, a non-issue. Like you said in your order to show cause, she was welcome to do it in her house. She didn't even ask to ask. She would have told in-house arrest what was going on, and she could have done it in her house. They chose to do it down there. The defense attorneys, I know they want to take blame for this. This falls on her. She's been dealing with you way longer than they have. She's been coming in with different motions over the last couple of years, trying to nitpick at in-house arrest. When she's arrested in her house. And this was a clear violation of it. It was designed to sneak around so the court wouldn't know about it, so the in-house arrest wouldn't know, and the court wouldn't know, and the state wouldn't know. Nobody would know that this show was going on until, wham, it pops up on the
Well, you
television.
couldn't really hide it when she was on 2020.
No, but it was clearly well hidden before she showed up on the show. I don't know exactly when she met with 2020 down there, but there was no question that this is a violation of the court's release conditions.
Okay, let me hear from defense. Flagler, you can argue this?
I am. Good afternoon, Your Honor.
Good afternoon.
The state is correct about a number of things. Being on house arrest is a privilege. It's no joke. And my client for 6.5 years has taken it extremely seriously. There's never been a violation. I disagree with counsel when he suggests that we're trying to cover for her. Dalia Dippolito will not be the first client in my close to 24 or 5 years that I will ever cover for unless she deserves and warrants it based upon the facts. So let's go to the facts.
Can I start with a question?
Sure.
Would you agree that traveling down to your offices for purposes of an interview with the 2020 news crew would be a violation of the conditions of her in-house arrest?
In general, with no more facts, with the stuff that I'm going to tell you occurred, probably, yeah.
Okay. All right, go ahead.
Okay. But there's a lot more that the state didn't know. I don't even blame them. I told some of the stuff to him over the phone, and those were his marching orders, and so he filed it.
All right,
Okay.
go ahead and fill me in.
Okay, so first, just to make very clear, Dalia is being charged with willfully violating her house arrest. As she indicates in the affidavit, which I hope the court had a chance to read, she makes it very clear that first, Mr. Claypool, who was organizing the 2020 interview, told her that the interview would be conducted in my office. She also was told by me that I would take care of getting permission, doing the paperwork to get her to come to my office, which is how we do things, okay?
Paperwork with in-house arrest? Or
That's correct, with house arrest, okay? So as it relates to Dalia, while the easiest thing for us to do is to tell the court, we had some discussion prior to her coming to my office where Dalia said, I'm concerned. Can I really go to your office for these purposes? And either Brian or I could have fallen on the sword and said, we told her yes, but that didn't happen. And I will not be intellectually dishonest with this court. The next best thing happened. By inference, she believed correctly that we were okay with her coming to her office, to my office, and I'll tell you why we were and still are. So she relied upon implied consent, implied advice from us that it was okay for her to come. Okay, so why would we do that? Why would we say it was okay? Why would I participate in something like that? First of all, the interview that took place was only a small portion of what took place in my office and what we had planned for that afternoon. It was probably about 20% of the time that Dalia was in my office, which was about 4 to 5 hours. It's rare that Brian Claypool is ever down in South Florida, and from California, and it's even more rare for me to have the desire and opportunity to drive alone to go to Dalia's home to talk about legal issues with maybe Brian on speakerphone. That's not how we did things. So knowing that we were going to meet for the purposes of this 2020 interview, we saved many issues that we needed to discuss. Dalia knew that in advance. The motion to dismiss was approaching. Dalia is very different than many of my clients. She is hands-on. She wants, if you're going to cite a case, she wants to know what that case is, why you're putting it in there. We had to discuss the purpose of the motion to dismiss. Who would we call as a witness? Would she testify? What were the benefits of that? We also had many media requests around that time. Let's wait. We'll talk all in my office about all those issues. We've got plenty of time. We'll use our time wisely. So the purpose of the meeting, and I'll get to the 2020 interview and why I believe that was trial prep as well, 80% of it was us fulfilling our promise to her to discuss those legal issues. There were many issues that we discussed. Now let's talk about the 2020 interview. I didn't want to say the following without first getting permission from my client and Mr. Claypool, and they've authorized me to say the following, and I'm doing this only so the court understands my thought process. I was vehemently opposed to this 2020 interview for so many reasons. I still am. Putting my client to talk to somebody, it's not my style. I don't do it. I was opposed. But, like many decisions we make, we do it as a team, and then I support the decisions being made. Mr. Claypool had arranged this effectively, told them certain things that they could discuss and not, and we all worked together to ensure that this worked out the best, in spite of my ongoing objections that I noted through many emails and calls and texts. So my mindset was, the purpose of this 2020 interview, whatever, they're doing this 2020 interview in my office, and I certainly wanted to be there and didn't want to do it at our house, but my purpose in my head was, here's an opportunity for me to watch Amy Roback, who I know is as a hard-hitting interviewer, question my client in detail from beginning to end. I mean, from the personal stuff when she came out of her mother all the way through the current day. And why was I not comfortable doing that? In my extensive career, I know that one thing that erodes a relationship more than anything is that time when you sit down with the client and you say, let's get into detail about your testimony. And what I'm going to do is, I'm going to play the role of a prosecutor when they give me responses, whether they're innocent or guilty, and I'm going to say, but wait a second. If you say you are acting, where's the script? And if you say this, and then what happens is either the client appreciates what you're doing, or it erodes the relationship very quickly, where they think, which side are you on? And when I first joined this team, even to this day, Dalia has a tremendous distrust, to some extent, certain reservation, I wouldn't say distrust, but a concern about all of her attorneys. She's been through so many, and I knew that if I could stand off screen, as I did, and take in-depth notes on not only what she was saying, but the manner in which she was saying it, and then give her immediate feedback after, I can justify in my mind at least one positive part of her doing this over my objection. So that's
Are you suggesting this was trial prep?
Absolutely. In my mind, it was, Judge. If I told the court that we needed permission to have Dalia come to my office and hire someone to vigorously cross-examine her, and then we'd have people there to give feedback on it, you'd say, okay, well, that's part of trial prep. In my mind, okay, the way I looked at it, after the deed was done, after Mr. Claypool and Dalia agreed this is what they wanted to do, I looked at it as the way that I could evaluate her testimony in detail, and it really was absolutely a wonderful, up to that point I had not heard in detail, I had parts of what her story or testimony was going to be, but I had not gone from beginning to end like was done in my office that day. I was looking forward to it, and when it happened, I took in-depth notes and discussed that with my client in detail. It makes no sense that Dalia, who for 6.5 years had no issues, knowing that in 1 month from that interview time, it would air for everyone to see, including the prosecution, their office, this court, that we were trying to pull one over on anyone. It in no way occurred to any of us that this was anything other than trial prep. It just was. I will tell you also that she relied upon our advice. Do I wish I could turn back the clock? And I've been analyzing this. If I could turn back the clock, knowing what I know now, the only reason why I would do things differently, Judge, is because I don't want to be in the gray. I don't want the prosecution, who doesn't know all the facts that I'm relaying to you, to even look at what we're doing and interpret it as anything other than what it was. Preparation for either the motion to dismiss or trial, and build a rapport between a client, all the things that I do when I'm preparing in a case. So, respectfully, she has done absolutely nothing wrong. It was anything but a willful violation, and I would plead with the court to understand what our mindset was in this case, and in no way did we think that it was anything other than preparation for trial, and certainly permitted under the umbrella of what this court had authorized. I'd ask that the court deny this motion.
Okay. Mr. Wind, your motion, you get the last word. Well, you've heard the argument. Is there anything you want to add to the response?
The only thing I can tell you, Judge, is the things I heard it was not detailed questioning about the facts of the case, that it was very bare bones. That's why I wasn't interested in seeing it. But that's the information that was relayed to me. This wasn't a prosecutor cross-examining her.
Can I just add one thing to that, Judge?
Sure.
As I think the prosecution knows and the court would know, what's aired is a tiny portion of what they do. And so, I mean, I'm representing to this court that there was a lot more that was questioned of my client than what was ultimately aired.
Okay. Anything further from other side? Okay. A couple of things. Candidly, I do not accept this as trial preparation. I just do not accept that meeting with... The court order basically says you can meet with your attorneys for purposes of trial preparation. I do not accept that the interview with 2020 was trial preparation. I think that was a violation of my order allowing in-house arrest. However, there are some other mitigating circumstances I also have to discuss. So I understand what you said. I understand the argument you made. I can tell you I do not accept meeting with 2020 to be trial preparation. Meeting with your attorneys, discussing matters in confidence with your attorneys, conducting mock cross-examinations with attorneys, that's trial preparation. Meeting with the media, although she has a First Amendment right to do that, she has an absolute right, if her attorneys believe it's advisable to speak with the press, she has an absolute right to do that. I think I made that clear in my footnote. The only question is where is it a violation of my order? I think it was a violation of my order. However, I do accept a couple of things. I think Ms. Dippolito was acting at the direction of her counsel, so I don't know that I can find that it was willful. And I'm not aware of any other violations of in-house arrest. Mr. Williams, are you aware of any other violations of in-house arrest? I'm not aware of any other violations of in-house arrest. So the bottom line is I'm not going to grant the state's motion in terms of basically vacating her right to remain on in-house arrest. She can remain on in-house arrest. What I am going to do, though, you've got local counsel here in West Palm now. Is that correct? Mr. Rosenfeld, are you in?
Yes, Your Honor.
Okay. I think the appropriate remedy, candidly, under the totality of the circumstances, is not to revoke her status of in-house arrest, but basically to revoke her ability to go to Miami at this point. So any further meetings with counsel now will need to be conducted in Mr. Rosenfeld's office here in Palm Beach County. You have a local attorney. There's no basis now to go to Miami-Dade. As I indicated, she has the right to speak with whoever she wants to. She has a First Amendment right to do that. If you all deem that to be wise, she can do that. But it's the travel down to Miami-Dade for a purpose not authorized by the court that is a problem. I do think it was a violation of the conditions of in-house arrest, but again, with respect to the remedy, I think the appropriate remedy is simply revoke the right to go down to Miami-Dade. There's been no other violations that I'm aware of in the time that she's been on in-house arrest. There have been requests that I grant certain privileges while in house arrest. I've granted some of those, denied some of those, but I'm not aware of her violating anything else. And again, I'm not sure I'd consider it willful if she was basically operating under the assumption that her attorneys believed that this was all right. It would be frankly punishing her for what her attorneys set up. So to that extent, I'm denying. I guess I'm denying in part and granting in part. I'm denying to the extent you're asking that I revoke her status in house arrest. I won't do that, but I will revoke her ability to go to Miami-Dade, meet with her attorney. She'll have to meet now in Mr. Rosenfeld's office here in Palm Beach County, which I assume is not a problem with you, Mr. Rosenfeld.
Not at all.
Okay, so she'll meet here. She can still travel to meet with her attorneys if necessary in Mr. Rosenfeld's office. Obviously, she can meet with her attorneys in her home if that's what she prefers to do. I'm simply going to revoke her ability to go down to Miami-Dade as a basis of this violation. Is there anything else we need to do at this time in this case? We've got a trial setting. I'm not aware of anything else that's currently pending. Anything else from the defense's perspective?
I don't believe so, Your Honor.
Okay. All right. All right. So this hearing is concluded. We're in recess.
Court is adjourned.
Hey, I'm doing great.
Yeah. No worries. That's the hardest thing to do today. I'll be all right.
Pretty steady, I have to say.
Well, the ground doesn't move. I said to make sure I didn't lean on the thing at all, because when people sat down, the thing rocked, so I kind of had to hold it just off the edge of it. Yeah.
Well, we'll go downstairs and get a thing. I'll grab this box. Is there any more? Let him get the